Good evening. This is Rahul Reddy. We are live from Houston, Texas. Every Tuesday, we do bring in immigration updates. We do take live questions. So those people who want to ask any questions, they can chat with us, and then we respond to most of the questions. Emily, what do you have today other than the breaking news that you already published that there will be a second lottery? And of course, there's a 15 minutes video. Anybody wants to learn about it. But other than that, what are we discussing today?
We are going to be talking about immigration fraud and how the government uncovers it. Where do they get their information from? How do they come to these conclusions when they are revoking petitions or denying petitions based on fraud? And then we're going to talk about the recent USCIS announcement that they are kind of easing the requirements of H-1B filings for people who own the business that is filing for them, even if you're a majority owner. What is that based on, and what's different now? Is this based on the regulation that they proposed? So we'll talk about that. And then, as you mentioned, the second round of the lottery, we should be getting selection notices for that any day now. And lastly, updates on the PERM labor certification process in the new FLAG system. Weird things that are happening with the approval notices, weird things that are happening with USCIS when the I-140 petition is filed with this new PERM approval. So we'll give you updates there just so that you're aware of the issues and can plan accordingly for any delays that might come up because of it.
Emily, this employer who owns the company, being an employee with the same company, let's say a person owns company A. Can the person be with the same company on H-1B? Historically, there have been a lot of changes. Long time ago, when I started practicing, it was not an issue where there was an administrative opinion that, yes, the company owner can have the H-1B. Then came the employer-employee relationship. There are some restrictions on it, and now we're having a memo that they want to implement from starting December, that they may loosen up the restrictions that the employer can also be an employee. What are the current restrictions? Let's say I want to own the company. Let's say I want to own 70% of the company, and then I want to be an employee of the company. What are the restrictions right now? How can you file the H-1B with that company for me?
Yeah, so there's still a restriction on self-employment. So even though you're the majority owner of the company, you have to show that the work that you're going to be doing is specialty occupation work, which generally does not involve managing the business. These are non-qualifying functions. So if you are owning a software consulting business, when you're doing the software development work, those are qualifying functions. So the company could sponsor you as a software engineer. The company cannot sponsor you as a manager or a business development manager or something like that, because that's not a specialty occupation. It does not require a bachelor's degree in your particular field of study. And so you have to worry about the job duties and make sure you're restricting yourself to only those duties that qualify as a specialty occupation. And then the other restriction is on the wages. You do have to be paid as a W-2 employee. So business owners can kind of choose how they receive their income. Sometimes they just take distribution of profits. But in this case, you have to be on the regular payroll, and you have to be receiving regular payroll. Whether the company is doing well or not, the company has to keep paying you the set wage that was specified in your LCA. So kind of what's changed between a few weeks ago and now is, a lot of people were concerned when the H-1B worker owns the majority of the company, and we're not filing in that situation. So I think prior to this announcement in July, a lot of people were filing petitions where the H-1B owner has the minority ownership, because it's clear that there's a majority owner that controls the company. Still had the requirement of it being a specialty occupation, still have the requirement of it being paying the prevailing wage and complying with the LCA. But now USCIS is coming out and saying, even if the H-1B worker owns the majority of the company, it still can be done as long as those things are complied with. Now, We had a proposed regulation last October that is not finalized yet that would go even further to give people the opportunity to do some of those non-qualifying functions, even though they're not specialty occupation. That is not final yet. It won't be a final regulation until probably December at the earliest. That's when it is showing on the unified agenda.
So what is the new proposal, Emily?
So back in October, they were allowing owners of the company to basically self-sponsor, even if there is no employer-employee relationship, but they were limiting it, if I remember, to just 1-year increments, especially for the startup companies until the company grows. So it's basically making it even easier to file an H-1B in that situation. So what we had before was pretty restrictive in that you couldn't be a majority owner. Now they're saying even if you're a majority owner, it's still okay as long as these other requirements are met. And then December, we may have an even more loosening of the regulations to allow you to even do some of those non-qualifying functions, but your H-1B is only going to be issued in 1-year increments.
So what you're telling is from December onwards, the person who is a software developer can also do partly management duties, partly going to the bank, operating, signing the lease, and certain other non-IT functions also in the example of IT jobs. So they can do some of those functions, which there is some restriction right now that they couldn't do it. So that's practically what you're telling is they are more liberalizing, they are more trying to promote the entrepreneurs to also sponsor their own H-1Bs. The company that majority owner is owned by H-1Bs also sponsor their H-1B. So they're going in the right direction in a favorable where the H-1B people can own and can be a startup company owners. Of course, the paperwork is a little bit more heavier side than compared to the normal side, but still it's getting more liberalized.
Yep.
Emily, now I want to discuss about the immigration fraud. How does the USCIS finds these things? A lot of people are very surprised though. But what I noticed recently is that a lot of people who go to visa stamping, they've been called into a small room and they've been asked questions which they're very uncomfortable about. And all of a sudden, all their information, the consulate knows it. And here is the surprising news, Emily, is that every time I speak with this client, who's been, not every time, but at least a majority of the time, some of the clients are they come out very clean. There's some misconception about it. They come out very clean, but a good number of them, the consulate has a lot of information. In some cases, these people have worked for multiple jobs without a H-1B concurrent filing, H-1B I'm speaking about, not legally, and they have received cash in India for their work in USA also. What I noticed is that when they go there, they confront them, did you work with this company? And they're shocked to know how do they know about the company. Now, the government has many resources to find out. One of the main resources is the individuals itself, though, because when the people that I speak with, when they were been in that room, they gave a lot of information about the companies that were involved in it, the people that were involved in it, the employees that were working illegally in there, and they took a notes of all these people. And when these people who are involved in like multiple working companies without authorization, when they go, they will be able to get them at the visa stamping, and they will be asked questions at that point of time. Now, we are not speaking of those people who are working multiple jobs when they are legally authorized. On the H-1B, there's a concurrent employment. On the H-1B, a person can have multiple projects. On the H-4 EAD or adjustment of status EAD, they can work for multiple jobs. That's not what we are speaking about. We are speaking about people working without authorization. Now, there are many other instances, not just working alone. If people were involved in illegal activities, the consulates are able to know, they're able to disclose this information. At the same time, they extract more information on this particular individual, where the other people who are involved in that operation, their information is also known, and their information is also noted. At a later time, when they go to the consulate, they get into trouble. So whenever people are in United States, so I strongly recommend don't try to get into any illegal activity. If you have any doubt, check with a lawyer to see if that activity is legal, and don't take any money under the table. Now, straightly get the salary. That's the best thing. If anybody is paying, oh, I am paying a person in India. How do they come to know? They will come to know some or the other. There are many different ways they will come to know. Because sometimes when the company owner is been caught, they disclose all the information where they have taken the money from. In that case, they won't tell their employees that they did went to USCIS or ICE and informed about the activity which they have done. Let's say, for example, an employer has taken money from 50 people, or he will inform all the 50 people's name. And even though now at this point of time, you're not working for that company, let's say you're working for a major corporation, but still you did the activity before, when you go to the consulate, they will discuss about what you did, what money you paid. So these are all money laundering things. There are kind of felony charges in United States. Do not involve in any of those things. A lot of times when people say, "Oh, I don't have a job. I just lost a job with this big company. I have this consulting company that is filing with an in-house project." Without a project, and they want to hire me, and I'm paying them H-1B money in India. No, don't do that. Actually, there are many legal ways if you want to maintain the legal status. You can move to B2 visa, you can move to F1 visa. There are different visas that are available. Don't resort to these kind of activities. The consulate, the USCIS, the ICE, they will come to know these activities. Don't involve in it. We do see day in and day out, we can get consultations on this topic. And they get lifetime ban to ever come into the United States. Anything else, Emily, on the topic before we go?
Yeah, and just think about all the information over the years that you're submitting to the government when you are submitting the DS-160, when you are filing a labor certification, when you're being registered in the H-1B lottery. All of that stuff is government databases that they do data mine. And they can put two and two together pretty easily when they start seeing patterns in this data. And they also have access to the Secretary of State data from each state. This is where companies have to register. Every U.S. company, if I start a business in Texas, I go to the Texas Secretary of State and I file articles of incorporation. Those are going to list my details as the owner of the company. All of that information is publicly available, and family relationship details are available. So the government has a lot of ways to piece things together and see how different companies are related to each other based on the filings that they've done with the state, even if they've not disclosed that to the Immigration Service in any immigration filings.
In recent, some of the intent to revoke, Emily, even though the companies are unrelated, they have noticed that the companies, when they register for the lottery, they register from the same IP address. So in cases they have where they have used the same FedEx tracking number, I mean, it's just hundreds of different things that they will be able to file it. I'm not telling that, okay, just try to correct these things. No, we are not telling those things. We're just telling you stay away from any fraudulent activity. You just don't do it. That's the best thing. This is the rule of the law country. That's the reason why we are here. That's the reason why we are immigration lawyers. It's not that the talent is not there outside United States. It may be there, but the reason why US is, it's a rule of law country. That's the reason why you should respect the rule of law. Emily,
all right, so we have
the second lottery.
The second lottery update today. So what's different this time around is USCIS confirmed that they have filled the master's cap. So this is the extra 20,000 that are set aside for just U.S. master's applicants. And now they're looking to still fill the bachelor's cap, the regular 65,000. But just because you are a master's cap person, if you were not selected before, doesn't mean you cannot be selected in the bachelor's cap. So you actually, everybody who is submitted in the electronic registration back in March who's not been selected yet goes into the second lottery for them to select more. Do you have any thoughts on how many more you think they're going to select?
As Emily, you pointed out early in the morning that last time they selected 35,000 extra out of the 85,000, which is 20,000 for the master's quota and 65,000 for the bachelor's quota. They did select 35,000 extra, 120,000. They still did not meet. According to the press release today, they didn't give how many people applied by June 30th. They did not give any of that information. They did not give how many people they are going to select this time. So they left it very open, though. It's very hard for me to tell that how many people they still are going to be selecting. One thing is pointing out it may be less numbers only. One of the reasons is that they're saying master's quota is done. What does that mean? Is that those people who have been selected in the master's quota, they filled up the entire thing. There is nothing left in there. So it's only the bachelor's quota people that were filed, that were supposed to be filed, did not file. Definitely economy played one of the role where some of the companies backed off between April and June 30th. They did backed off on filing the H-1Bs. Also, I think so that to some extent, Emily, the H-1Bs that were been revoked because of fraud, especially this administration went very tough on fraud. They have done a lot of different methods in curtailing the fraud. What I have seen is that if the revocation occurs this year, so let's say, for example, in the fiscal year of 2023, the H-1B selected, but they did revoke, they did revoke, it may come up in this year. So that's probably one of the reasons they may have, they may anticipate some of the things that they're going to revoke next year. That's what I'm thinking. May pop up, because if it's been revoked from October 1st of 2024 to September 30th of 2025, it will come up. They may be anticipating some revocations of the H-1Bs too. So we have seen some revocations that have happened because of the multiple filings and some internal job postings and fraudulent filings that will be added up. So we'll have to see how many of those things will be added up too. But yeah, master's quota is complete, only bachelor's quota is there. So I am expecting between 15 to 25,000, Emily, to be selected in the lottery. What is your expectation?
Yeah, that's what I'm thinking as well. I think last year when they did the additional round, there were quite a bit more selected the second time around. It went from, they initially had selected 110,000 and they ended up selecting 188,000 to get to the 85,000. So they selected another 75,000. I don't think it's going to be anything like that. I think it is just a matter of a small percentage. The jobs are no longer there. I think a small percentage maybe for the revocations being added back into the pool. And I do still think that there are employers that are, you know, because it's only $10, they're just submitting a registration and we'll figure it out later. We'll find a job later, even though when they're registering, they are supposed to be attesting under penalty of perjury that they have a valid job offer at the time of submission. I don't think that's stopping companies from going ahead and registering people, even when they don't have a job offer. And so when those people do get selected and they end up not having a job offer, they just don't file. Be interested to see any data about the percentage of companies that you know, end up being non-filers, because I think there's some companies that it's probably a trend that they get all these selections and then don't proceed with them.
Emily, now there's a new flag system and we started receiving the approvals in the new flag system of the PERM, which is supposed to be expedited. The PERM looks completely different from the traditional PERM application that we have been seeing from 2003, 2005. It's been forgotten. It's been like
2005, I believe.
2005, yeah. It's been 20 years that we're seeing this PERM application, PERM. All of a sudden, this looks different. How about the immigration? Did the immigration know how it looks like? What's going on with the labor segregation?
It does not appear that there's been a lot of discussion between DOL and USCIS, because there have been attorneys reporting getting rejections of the I-140 petition where USCIS is saying you failed to submit a properly completed PERM labor certification. So I think whether it's in the mailroom or what the issue is, but when USCIS is getting those I-140s that have the new form, they're not familiar with it yet and they are rejecting. We've heard reports of that. I don't think our office has had that issue yet, but it's something we're definitely monitoring. So be aware that it might take longer than usual to get a receipt notice for your I-140 petition until USCIS figures this out. And then just the Labor Department has already had a glitch in issuing these approvals. You know, when we file a labor certification, we have to provide the prevailing wage information that comes from the Labor Department. And part of that is an SOC code, which you may be familiar with that because we use it on LCAs for H-1Bs. We also use that in the PERM process. The SOC code is kind of the occupation, broad occupation, the name of that, which is a lot of times different than the actual job title of the position that the person is being sponsored for. While DOL has been issuing these approvals, listing the job title as the SOC code title rather than the actual job title. That was brought to DOL's attention. They've fixed that glitch and are going back and reissuing PERM approvals to correct that. So attorneys are able to go back into the system and click in a different place and get the newest version of the labor certification that does have that correct. But it's just another, you know, proof that our government is not efficient, is not prepared, does not pick the best technologies and plan things out like they should for a properly functioning immigration system.
Anything else, Emily? Can we go to questions?
I think we are good to go to questions.
Questions from Avi. He has a DUI. He did disclose it in the green card application. He did got the green card. Now he has an N400 interview. Can he go for the N4? Is he expected to get into any trouble for the N400? Absolutely not. No, not expected to have any trouble. Will they question him about the DUI? Yes. Do you need to take the documentation about the DUI? Yes. But will there be any problem? Since this DUI is more than 5 years old, absolutely will not have any problem in you getting the citizenship at all.
Nisha says, my spouse is working on H-4 EAD and his H-1B got selected this year in the lottery and has already been filed. And she wants to know what are the ways he can actually change status back to H-4 after October 1st. Nisha's H-1B is due for renewal in February 2025. This is where the margarita switch that we talk about quite a bit can come into play because your spouse has a valid H-4 approval notice, I'm assuming, or a valid H-4 visa, an I-94 that's good till February 2025. Now they have an H-1B approval notice that starts October 1st. If they want to actually go back to H-4 EAD after October 1st, can take a quick trip to Mexico, have a margarita at a resort, and come back and show the H-4 visa and the H-4 I-94 to be given re-entry in H-4 status. That will only be valid till February 2025, and then you can all file your extensions. So that is the easiest way to do that. Otherwise, it would be if you go to your home country and don't have a valid H-4 stamp, you can go for stamping based on the H-1B spouse's approval, or you can file a change of status on I-539 to go from H-1B back to H-4. But the easiest one is the margarita switch. We've talked about it quite a bit on here. And so if you need more information about that, you can always consult with one of us or join one of our daily conference calls for more details.
Ritika has this question. She is on TN visa and she had a H-1B before and she's filing an I-140. Is it recommended for the spouse to be an H-4 EAD or on a TN visa? Definitely H-4 EAD is much flexible, much easy to maneuver than that of the TN. Since if you have an I-140, if the main spouse has the I-140 approval and the H-1B, H-4 EAD is much better because if the flexibility, you can do multiple jobs. There's no limitation on what you can do on H4 EAD. Question that is coming from Rajiv is, for the people who filed the multiple registrations, how do we know if they are being hit with misrepresentation? That means barred forever to come into the United States. It's going to be tough to say that one. Only there are situations where you won't be able to find it. Even if you file a freedom of information, you may not be able to find it because the determination will only be done mostly at the consulate when you go for the interview, though. That's when they are doing the misrepresentation. Sometimes they're doing it at the H-1B when you're trying to extend the H-1B or when you're trying to transfer from company A to company B, but most of the time it's when you go to the consulate, they hit you with a misrepresentation. Until that time, they won't. I mean, they will give an opportunity for you to speak, and then after that, they're hitting with a misrepresentation.
AK says we got our green cards. Congrats. My wife and son are in India, though, and they have valid H-4s till 2025. For them to come back, do I need to mail them the green cards? That's not necessary. CBP is able to verify that they are permanent residents when they're entering, so they can use their H-4 stamps to show the airline to get boarded onto the plane, and then once landing, they can let CBP know that they are green card holders. CBP can confirm that in their records. Should not be a problem at all. I've never had anyone have any issues doing that.
Two questions on the green card. One question is from VM that he's saying that he is a green card holder. How long can he be unemployed? I mean, you can be unemployed for the entire period of time. There is nothing. Will that affect your citizenship application? Absolutely not. Absolutely not. One person, Roy, is a green card holder. He applied for the citizenship and his 485 interview is coming through very quickly. He lost his green card. Now, can he still go with a photocopy of the green card? Absolutely, he can go. When you go there, they will do your biometrics, Roy. And if you're a Roy, of course, I do expect you are the Roy, then you'll be fine. And if you are somebody else speaking as a Roy, of course, they will detain you, which I don't expect that will happen with you. But yeah, shouldn't have much problem in you getting the citizenship because they do the biometrics to identify whether you are the real Roy or not.
AJ says, my company and attorney are not sharing the details of an RFE and the response that they submitted. Do I have any options? I'm assuming this is either for an I-129, which is for an H-1B or an L or something like that, or it's an I-140 petition for EB-2 or EB-3 green card. In that situation, technically, you have no rights to that. You are the beneficiary. You're not the petitioner. You get the benefit of the approval of the petition, but you don't get any involvement in the process of it. So there's no way to force them to give it to you. It is not, you don't have a right to it by law. So it would just be, negotiating with them on that to provide that information to you.
Are you expecting any advancement for the EB2 India? His priority date is January 2023. I will be very surprised that if you would reach in the next 10 years. If the things remain as it is, I hope things will change. I hope I go wrong, but according to my estimate, in the next 10 years, very unlikely that your priority date will be current unless things change.
Sunny says, how can I expedite the approval of an H-4 EAD when the H-1B applicant's extension is not expected in the near future? One of the ways to do this, if the company is willing, is to actually file an H-1B amendment. Even though it's not necessary, as you mentioned, the H-1B extension is not due anytime soon, and you can't extend the H-1B, you can't file that more than 6 months in advance, but you can file an amendment plus extension at any time. So that would be the best way to do that. Otherwise, you're just looking at normal H-4 EAD processing times and trying to do an expedite request through USCIS if you can meet any of those criteria. Even if you do meet the criteria, it is completely discretionary, so no guarantees there.
Is it mandatory to match, to have a better salary when changing the employer on adjustment of status EAD? Absolutely not. It doesn't have to be a better salary. Let's assume that you're making $100,000 salary, and the next job you're going to be only getting paid $85,000 salary. Is that okay? Absolutely not a problem. Not every time people change the job, the salary increases. Not every time as the years pass by, people do improve. Sometimes they go from one level to another level. Look, Emily was a law clerk at one point of time. She's the managing partner of the office. I was the managing partner of the office. Now I am not. There's nothing wrong with it. People do go up and down, especially the salaries also do. Nothing wrong with it. You absolutely will have no problem in getting the green card if your salary goes down on adjustment of status EAD.
Ratika says, my spouse is Canadian and on TN. I'm on H-1B. You already got that one?
Yeah. Srinath has this question. He's an adjustment of status EAD, EB2 on a NIW, and his EAD is valid until 2029, but recently got laid off a month ago. Am I eligible to start my own company and have myself and my wife work through as a contractor? Yeah, technically speaking about, can a person on the adjustment of status be self-employed? Yes, you can be, but I would want some parameters that there must be a corporation, there must be a payroll running. We had some interviews where we went to an adjustment of status. We've been successful in them. In fact, there is a memo from the USCIS that the self-employment is allowed on adjustment of status EAD as long as you're working in the similar profession. However, I want to take it with a caution, because these things, even though the memo says it, the law says it's okay, sometimes we have to explain it very clearly to the USCIS official that this is what the law is, this is what it is. So it may be a little bit, it's maybe better that you discuss with the lawyer, take some precautions, open a company, have the payroll run before you embark into the journey of just being a self-employed.
SH from X says, do you think PERM labor certification speed will be improved as it's taking 14 months now? I don't see that happening. I don't see any kind of accountability from Department of Labor for their longer processing times. They don't seem to care. And we've filed some lawsuits on that. Maybe we'll get some traction through these lawsuits, but I think them switching over to the flag system, I don't think they have any plans to make any improvements.
Tex-Mex has this question. Parents had green card but went back to India just before COVID-19 and never returned and is no longer valid. Can they still apply for the B1, B2 visa and our green card? They can apply for B1, B2. Absolutely they can. If they want to do it, I would recommend that there is a surrendering of the green card, even though the green card is not valid, even though the green card might have expired. There is something called surrendering of the green card. There is an application form at the consulate. You just have to fill it, and you have to give, if you have the green card original, you give it to them, and then you can apply for the B1, B2. He also asked, Tex-Mex also asked that can they apply for the green card also if they are eligible, assuming that you are a US citizen or whatever the eligibility that they have, and then you want to file for appearance? Absolutely, you can file the green card again, even though they had a green card, they have lost the green card, and by staying outside the country for more than 1 year, can the green card be applied again? Absolutely, you can.
Chowdhury says, my 7th-year extension got approved back in April, but still haven't received the approval notice. Is there any way to get it? So I'm assuming your employer has not received it in the mail. The attorney has not received it. Because of the amount of time that's passed, most likely the company is going to have to file an I-824 application to request a duplicate approval. Usually you have to reach out to them right around the 30-day mark for mail that's gone missing and see if they will reissue it. Because it's been more than that time, the file typically has been moved elsewhere, and they'll tell you that we can't issue you another approval. You're going to have to file an I-824. It takes, I think, I don't know what the new filing fee is. I think it's over $400, maybe more now. And it does take several months to get, unfortunately.
Question from Wesley Sundar Singh. Is there any update on the I-131 delays? No, none. It's random. For some people, they're approving along with the EADs. For a good number of people, they're not approving along with the EADs. It's taking a long time. But one good news is that when they are approving it, they are approving 5 years. On the same line of I-131, there's a question that came out. On the one person got a paper I-1 advance for approval. You get that when you apply. When they don't give EAD in advance for altogether, they do give a paper. And this gentleman got the paper advance for approval. And when he visited United States last time, they took one of the page of the advance parole, and now he's trying to come back from Dubai airport. They're giving a hard time. You can go to the consulate and get a letter from them, and then be allowed to come into United States. Sometimes the airline people and the CBP people at that point of time do contact the CBP in United States to see if they will be allowed into the country when you're boarding. So there may be some delay in there. For those people who are traveling on the paper I-131 advance for approval, I strongly request that you do make some copies and take it with you. Because when in the CBP, they ask you, just give one copy so that you don't give the original, you keep the original, you give them the copy. Because otherwise, the difficulty what happened to this gentleman in the Dubai airport might happen to you.
Jay says, regarding the second lottery news, can someone who got in the lottery as a bachelor's degree who now has a master's degree switch to the master's cap for the second lottery? No, unfortunately. So whatever lottery, whatever cap you were submitted under in March, that's what you're stuck with throughout any number of lotteries that happen for this year's cap, the fiscal year 2025. So if you want to now go in the master's cap, you have to wait until March 2025 to get into the fiscal year 2026 lottery.
Srinath has this question. Is the self-employment allowed for the people who are not national interest waiver? Absolutely, yes, that is allowed too. With some cautions, with the advice of a lawyer, you can, definitely, it's an option. It's not only for national interest waiver, it's for EB2 or EB3 or EB1. It's allowed for it. Manoj has this interesting question. He's working for company A and he intends to work for company B at the same time. As people, most of our audiences already know that company B can file a concurrently filed H-1B and start working for the second company at the same time. His question is that, does the second company job and title and the level of salary has to be the same as the main H-1B? Absolutely not required. The company A job can be level 4, company B job can be level 1. It depends on the job, not your qualification though. If you're qualified, you may have a doctorate, super doctorate degree, I don't know, maybe 25 years experience, but the position requirement is what determines the level of the salary, not your qualification. So that the company A and company B level does not have to be the same.
Rakesh says, when is premium processing coming for H4 and H4 EAD? Unfortunately, it's not. I don't think there are any plans to do that. We thought when Congress issued updates to USCIS to help their budget woes a couple of years ago with the expansion of premium processing that they were going to add it for H4 and H4 EADs because there's been so many issues of people losing work authorization and losing jobs because of it. But as they were making the announcements about the different expansions, where they expanded to EB1C and then they expanded to OPT and to F1 and things like that, once they got to the end of it, they made very clear they had no plans to do anything else. So I would not expect that at all.
Emily, I want to pause for a minute on this particular topic. There are a lot of questions coming on the H4 EAD expedited. Is the premium processing there? How can I do? Except for the first time when you get an EAD, where there are exceptions, but most of the time you won't need the premium processing, Emily. If you attach the H1B, H4, and EAD together and file it, you are getting along with the H1B. If not, we will take care of that one. We can contact the USCIS and get the H4 and EAD approved. In other words, you pay one premium processing, H4 and EAD gets approved together. And in cases, there are some companies that do not want to attach the H1 and H4 and EAD together. They can still file the H1B and H4 and get the premium processing approved, Emily. And you can file the H4 EAD extension. And based on the new rules recently, if the H4 is extended and you applied for the EAD extension in the proper timing, you get an automatic 540-day EAD extension. Now, there are very limited circumstances where you would require expedited EAD if you plan it properly, though. Now, there are at point of times when you're filing an EAD first time, H4 EAD, we may not be able to help you at that point of time unless you go through your employer and file a H1B even when the extension is still not to do it. We may not be able to help in that situation, but in 99% of the other cases, we will be able to help you to get the H4 EAD in one or the other way by either going to Margarita switch or by probably filing the H4 extension with the company's H1B and get it premium processing approved. There are multiple methods where we can speed up the things. Not all the time, but a good number of times. But it's better that you contact the immigration lawyer well in advance. If your EAD is expiring on August 2nd, do not contact us on August 1st saying that my EAD is expiring. Do contact us by June 30th or at least even before that. Then we may be able to have some methods, side methods to do it, Emily. What do you say, Emily?
Yeah, I think the vast majority of people are able to get a timely H4 EAD, either making sure that the H1B is filed early enough, just not delaying till the last minute. But there definitely are people that have some unique circumstances and get into that limbo situation where they might need an expedite.
Yeah, but if you plan early, a good number of people wouldn't need that expedited thing.
Mm-hmm. Actually says my F1 visa expired June 7th, 2022. I left the country 10 days after that because I was in my grace period. Does that affect anything or future visa applications? It's very important to understand the difference between the visa expiration and your status or I-94 expiration. The visa, this is the stamp that you got in your passport at a consulate outside the U.S. It only has to be valid on the day you are entering the United States. The visa is what gets you in the door. Now, once you arrived on that F1, you were given an I-94 that probably said D/S for duration of status. That means as long as you're maintaining your F1 status and have a valid I-20 or a valid OPT, you can continue to stay in the U.S. Even if you're on F1, maybe you're doing a PhD now and your F1 visa stamp expired 5 years ago, but you've maintained your F1 status, you have a valid I-20, that's totally fine. You do not need a visa stamp to be valid while you're staying in the U.S. You only need it to enter the U.S. So because you mentioned that you were within your grace period, so that means you had finished your program, either your OPT expired or your program end date came along, and then you have 60 days of grace period and you left during that time, that was totally allowed. You were maintaining your F1 status properly. The visa stamp expiration has nothing to do with it. Totally fine.
Can a person get I-140 approved in two different categories? For example, EB3, NIW, and EB2 app. EB3 and NIW, EB2, sorry. The answer is yes. Can a person get an EB3, EB2, and EB1? Yes. All three of them, they can. My prior to date is 2016. Can I expect EAD in the next 5 years? Very unlikely at this point of time. Very unlikely, because to cross January of 2015, it may take a long time, and then you have 1 year afterwards. So very unlikely, unless there are some changes. I think, what about the lame duck session that is coming up right now? Can we expect something? Because every time in the lame duck session, we had something or the other going on or taking the per country limit. At the time when Obama was leaving the lame duck session, we had the per country limit coming up at that situation where it didn't went through that much. When Trump was leaving also, the same issue came in of the lame duck session, but it was passed in the Senate, it was passed in the House, but unfortunately, it's not the same bill that was passed, and then we have to give up at that point of time. And the lame duck session is after the elections, that means after November, before the new Congress, that the Parliament in the United States is called as Congress, before the new Parliament comes in, so between November and January 6th, can we expect something, Emily?
I think that's our best chance. Again, as you mentioned, over the years, these bills are brought forward basically every 2 years. And every time they've been brought forward for the last 10 years, it's gotten closer and closer to the finish line. There's always been something that kind of happens last minute, but the number of people who support these bills, the number of co-sponsors on the bills has gone up every single year. There is still a lot of support for it. They've modified the bills over the years based on feedback they're getting from the opposition to try to make everybody happy on that. So I think that is our best chance to get something like that passed. So we'll have to see, how things go with the election. But there's a definite possibility if people don't sit on their hands and, then wonder why nothing happened. People have to actually be involved and share their story and talk about it and get support for it.
On STEM OPT H1B approved this year, going to start on October 1st. Do I need to inform, he's on STEM OPT, the H1 is starting in October. Do you need to inform the DSO or wait until October 1st? You can inform the DSO, but typically what we have seen is that on October 1st, you get kicked out of the civic system automatically. I would recommend that you take a note of all the civic system, print everything out, keep it in a PDF copy so that at a later date, if we have to go back, it's easy for us to go back. You should get kicked out on October 1st. You can inform the DSO right now, and make sure you inform the DSO on October 1st also that you are now on H1B.
Nisha says, I'm on H1B. Can I travel to India while my H1B transfer is in progress? Well, you've asked, can you do it? But the real question is, should you do it? Yes, you technically can, but should you? There are a lot of reasons why you should not do that. And a part of it depends on what's going on with your existing H-1B approval. If it's expiring soon and you leave and your transfer is not yet approved and your old H-1B expired, you don't have a way to come back. You have to wait till the transfer gets approved. What if your transfer gets an RFE? You get stuck. What if your transfer gets denied? You have no way to come back. So that's very risky from that standpoint. What if while you're outside the U.S. you get an RFE and the company doesn't want to respond to it? It's kind of like when you're out of sight, out of mind, they might not want to continue with that. So I definitely don't recommend it. Best to either file it, get it approved, and then travel, go for visa stamping while you're there if you need a new visa stamp, or travel and come back and then file the transfer.
Rakesh Sharma has some question with regards to the political asylum case and EAD. Rakesh, me or anybody in our office, we are not familiar with the political asylum case, EADs, or anything changing from there to any other visa. None of our office is equipped with it. I'm sorry about that. You may have to seek some other law firm to give you advice on that topic.
MK says, I've traveled using my AP, but I'm working on my H-1B. Do I need to extend my H-1 before the AP I-94 expires? No, you do not. So once you come back on AP, now you kind of have two different I-94s. Your AP I-94 is usually only given for 1 year, but your H-1B I-94 that's attached to your approval notice is valid, is still valid. So you still go by your H-1B approval notice I-94. You can ignore the end date on your AP I-94. That's about the only time you can ignore the end date on an I-94.
Can my wife, who is an H4, start a consulting company? Absolutely, she can. She's an H4 EAD. That's what you said. Yes, she can start any businesses. That's perfectly all right. Can she employ me in the H1? Under certain restrictions, as we pointed out before, that even though she is the owner, we consider the family ownership, under certain limitations, you could be employed on that and H1B. That can be achievable.
Sai says, once we have an approved I-140 with one company, if I move to another company, do we need to start the entire PERM process again with the new employer? At some point you will need to, but you may not need to do it right away. That's going to depend on, number one, assuming you've had your I-140 approved with the first company for at least 180 days. By doing that, you lock in your ability to keep using that I-140 to keep getting H-1B extensions with any employer. And you can keep getting H-4 EAD extensions for your spouse, even though you're no longer with that company. And the other issue is your priority date going to become current anytime soon? If you're in the backlog for India, where you're looking at decades of waiting for your date to become current, there's no need to get a new PERM and new I-140 approved every time you change companies, unless something weird happens like in October 2020 where the dates miraculously move forward. You need to be prepared for that. But if your date is nowhere near being current, there's no need to keep getting PERMs approved with every single company that you join.
MK has traveled on advanced parole. He has a H-1B valid, but his AP advanced parole I-94 is expiring. Does he need to extend the H-1B before the I-94 expires? Now, there are a couple of things here, though. Typically, what we are seeing right now is that advanced parole is given for 5 years. When people are entering into the United States, the I-94 for advanced parole is only given for 1 year. The people are asking me the question, when does my advanced parole expire? Does it expire in 1 year, or does it expire the date it tells on the advanced parole? Typically, it's 5 years right now when it is expiring. The answer is you can ignore the online I-94 only this time. This is only for advanced parole I-94. I'm not speaking of H-1B, I'm not speaking of H-4, I'm not speaking of B-2, I'm not speaking of anything else other than the advanced parole I-94. You can ignore it. You need to look into the advanced parole document to check when your advanced parole expires. Now, that's having said that, you do not have to extend the H-1B before the advanced parole I-94 expires. If you want to extend the H-1B, you need to extend the H-1B before the H-1B expires. So let's say, for example, you have traveled in August of 2023. Now your advanced parole is expiring in August 2024. And your H-1B is expiring in July of 2025. When do you need to extend the H-1B? Before July 2025 and not before August 2024.
Raj says, my F1 visa got refused on the first attempt and was later approved on the second attempt. Do I have to mention this first refusal for the H1 visa? So assuming you're talking about when you're going for stamping for your H-1B visa, yes, you do. There is a question on the DS-160 that says, have you ever been refused a visa? Even if you later got it approved, that still counts as a refusal. So be sure to disclose that. Failure to disclose that can be considered a misrepresentation, which can be major problems for you in the future. So definitely disclose that.
Question is coming with regards to the I-485J filing. When I moved from company A to company B on 485 application, do I need to file the I-485J? Do I need to file I-485 every time I move to a different company? You're under no obligation to file the I-485J. You're only needed to file the I-485J if there's an RFP or if there is an interview and you have changed the company, you need to file the I-485J. And do you need to file I-485J every company that you move? No. You don't have to. So you move from company A to company B to some company C to company D. It is when you get an interview or when you get an RFE on filing the I-485, at that point of time, whichever company you are working with, that's the company that needs to file the I-485J.
Harshal says many people are getting the green card with the priority date not current. Are these legitimate green cards? And other people are having issues with the classification being approved for EB2, but they're actually an EB3, things like that. Yeah, we do see this. I wouldn't say it's super common, but it is happening enough that it is a ridiculous problem that USCIS has. And it can have some major impacts because if you don't take action as soon as it happens. Because what the law says is when the green card was issued in error, the government is supposed to issue a notice of intent to rescind your approved green card. And your only options when you get that notice are to give up your green card or request a hearing before an immigration judge. There's no working with the agency to say, yeah, I noticed you approved this in error. Here's the card back. Can you put me back in pending AOS? Can you reopen my 485? Can you put me back in H-1B status? There's no discussion to make sure all of those things happen. So what we've tried to do in that situation is before a notice of intent to rescind gets issued, reach out to the USCIS ombudsman. They've been able to have us send the green card back, reopen the 485, reopen the H-1B, reopen the EAD and AP, confirming that everything is as if the green card was never approved. That's a much better situation to be in than USCIS simply rescinding it, and then you have no confirmation of what your current status is. Are you now just here unlawfully because you're not an H-1B anymore? You don't have a pending 485. They didn't reopen it. It can be a big mess. So be very careful with that.
Preeti, who had a question on the 485J, has also questioned that if she doesn't have a job, definitely on the 485, she is the main applicant. If you don't have a job, you will be risking the green card. They may deny your 485 application completely, though. There are some alternatives. Self-employment, as we have suggested before, is one of the other alternatives. Getting a job immediately definitely is a better option. If not, self-employment is one thing that you have to consider very seriously. And if you don't have a job, or if you're contemplating that you're going to lose a job and you're not going to have a job, it's better to have a consultation with the immigration lawyer to have an alternative solutions. What if you lose the job? What are the alternative options? Self-employment is definitely an option.
Yemeni says, I'm planning to apply for my F1 OPT extension, but my employer is not in the E-Verify system and not planning to use E-Verify for just one person. What are the routes I have to get my F1 STEM extension? You're going to have to find a new employer because you cannot file it if your company is not an E-Verify employer. And if they're not willing to do that, you don't have a choice. You need to find another company. Be very careful here. Please don't fall into the trap of these fake companies because they can get in the E-Verify system. It's very simple to do. All they have to do is fill out a form and sign a memorandum of understanding. Even a not legitimate company can do that. There's no kind of vetting. So if there's a company out there saying, yeah, we'll give you our E-Verify number if you pay us $500, we'll give you an offer letter, pay us $500. Run away. Don't do that. It's not worth it. That's how all these people got into trouble with Integra, Wireclass, AZ Tech, or I don't even remember all the names. It's a big problem. So find a legitimate employer that is using E-Verify and make the switch as soon as possible so that you don't miss out on 2 years of work authorization.
Samba Shiva has this, he's an L1, his dependents are 25, got a H-1B in the consular processing and he's going for stamping. Can he do the stamping and can he do the drop box for the entire family? Absolutely, you can. And you don't need to have any H-4 approval. In fact, there is no consular processing H-4 approval. So they can use your H-1B approval with the marriage certificate and birth certificate of your child and apply for their respective H-4s and get it based on your H-1B approval. Anything else, Emily?
Oh, 6 o'clock already. Nope, that's it for today. Thanks everyone for joining us. As always, we will be back next week on Tuesday at 5 o'clock Central Time to give you all the latest updates and continue to answer your questions live. If you would like, you can always set up a consultation with us or any of our attorneys by going to rnlawgroup.com and clicking on the consultation button. There you'll be able to see our schedule and book it easily online. So that way we can have more of a one-on-one discussion about your specific situation.
Thank you very much for tuning in.